We are live. This is PodShoot. We are speaking to you on July 10th, and I'm pleased to be joined today by Larry Salzman. He is the Vice President of Litigation, Research, and Policy. Is that correct? At Pacific Legal Foundation, you have
Yep.
three roles essentially all wrapped into one.
That's right, Amy. It's good to be here. Yeah, the roles are all in the legal department. So it's essentially the litigation team, which is roughly 55 litigators at this point. And then we have a policy team, which amounts to legislative affairs. So sometimes we win cases or we're pursuing cases and we want to do something in legislature. So we have a dedicated staff to do that. And they come under my rubric in the legal department. And then we have a strategic research team and a constitutional scholarship team, both of which are lawyers and social scientists who produce scholarship concerning the things that we do or produce data, empirical information that might help legislators or courts decide cases in the way that we think is appropriate.
So even legislators as well, you aim to help with your work.
Yeah, we do. And we keep it pretty tight. We're not a lobbying shop. We're a public interest law firm, but we have a strategy, broadly speaking, that we think of as entrenching and expanding and enforcing the work that we do in the courts. So sometimes you'll get a win at the Supreme Court of the United States or something lower, or maybe you find you can't get what you need in litigation. You get cases dismissed or you fail, but the rule is really bad. If we bring that to the attention of the legislature, sometimes they'll take the Supreme Court or the lower court wins and say, well, we should codify that into legislation for our state. And we have a team that will help them work on bills that will do that faithfully. Or if we're failing in the courts and we think it's a really important rule change, we'll pitch that to legislatures, or at least we'll be available to legislatures who are interested in changing the law to help them do it competently.
Okay, that's interesting. Yeah, because
it's a relatively small team. It's compared to the 55 litigators or so, we've got about 5 people who are doing policy things of any sort.
Yeah, because there were opinions this term that made you wonder whether litigation was going to be a fruitful way to pursue the ends that were trying to be pursued by the plaintiffs. For example, Murthy was one of those cases, I believe. But backing up a bit, Pacific Legal Foundation is focused on working towards limiting government, sometimes reestablishing limits on the scope of government. But what else? What is your sort of aim?
Yeah, we're a public interest law firm. We've been in existence since 1973. I think most people would regard us, or the history is probably true, that we were the first of the larger public interest law firms dedicated to the principles of individual rights and limited government. So contrary to maybe earlier public interest law firms or environmental ones or some of the social welfare ones that came up in the 1970s, we were really dedicated to, well, who's in the court standing for people who believe in limited government? And that was sort of our origins. Today, we have 3 major programs. We have a separation of powers program that we can talk about. There's a lot of action at the court this year concerning separation of powers. We have what we call an equality and opportunity program. We have a colorblind view of the 14th Amendment. So our civil rights practice is around advancing that view. And we think of civil rights broadly. It's how do we take down barriers in the law to people creating opportunities in their lives? So we don't want racial barriers. We don't want sex-based barriers. We also don't want protectionist, economic protectionism as a barrier to people earning a living and pursuing their livelihoods. So we really combine our equality and our economic freedom practice in one large group. And then we have a property rights group, which is probably our signature group because we've had maybe 12, 13 cases at the Supreme Court over the years on property rights. So it's what we're best known for.
And when you say property rights, what are you most concerned with? I mean, is it mostly residential? Is it commercial? Is it both?
Yeah, I would say our knitting is sort of land use focused, and that's just the origin. So of PLF, we were originally founded in California, although today we have attorneys in 25 or 26 states, and we're practicing in almost 40 states simultaneously right now. So we really are nationwide at this point. But when we were founded, we had more of a Western focus. So we dealt with a lot of ranchers and land use problems. And as that's grown, it's become land use in the context of home building or commercial use of property. So there's a lot of land use practice. Takings, due process, equal protection as applies to land use. Sometimes excessive fines with regard to property. So maybe you're familiar with a case that we had not this term, but last term at the Supreme Court called Tyler versus Hennepin County, which was the question there was, what happens if you're a homeowner who doesn't pay your property taxes and the government seizes your property to take the property taxes? In 15 states, 14 states, the rule was, prior to our case, that they would just take your whole house and refund nothing. And we said, no, that's a taking, really. It's either an excessive fine or a taking to take more than the government is owed. And the Supreme Court agreed with us and has mostly abolished that rule in 14 states. That's one of these issues where we're in legislatures right now saying, this is what the Supreme Court has said you have to do. Let us help you write legislation to codify that faithfully. And we're still working in some states to wrap that up. But that's an example of, it's not exactly land use, but it's property, has a connection to home ownership and land. But we really don't, we're not opposed to it necessarily, but we don't have a practice in intellectual property, for instance. We don't do a lot of intangible property interests. It's pretty rooted in making productive use in your land, being secure in the use of your property. So Fourth Amendment, Eighth Amendment excessive fines, due process with respect to property claims, equal protection. Sometimes people are just treated very differently in terms of land use for the wrong reasons, or takings. And takings is probably the dominant thing that PLF is known for.
You mentioned Fourth Amendment, so later I'll ask you about that. But going back to this concept of separation of powers, explain what that means, and then talk about some of the cases you've been involved with separation of powers this term.
Yeah, well, when we talk about separation of powers, we're just talking about the constitutional structure that sets up three separate branches of government: an executive branch that is there to enforce the law, a legislature that creates statutes, and a court that says what the law is when there's disputes about those things. And the fact that the U.S. Constitution, at least, separates those things very clearly. You know, the executive has certain powers the legislature can't usurp. The courts are not supposed to tread on what is the legislative authority. And this court, the Roberts Court, for some years has been pretty focused on what I would say reestablishing that separation of powers from the failure of the separation of powers that was largely rooted in the New Deal, but throughout most of the 20th century eroded and eroded and eroded to give a real life and a improper scope to administrative agencies, which are a executive branch function. They're the Securities and Exchange Commission, the Department of Labor, and their organs. There are all these administrative agencies, the EPA, that enforce presumably statutes that Congress passed. But because the separation of powers had broken down, the courts had allowed the separation of powers to break down. Over time, these agencies have come to fill in the gaps that Congress leaves in laws and sometimes expand the scope of their authority well beyond what Congress wrote down or certainly intended. They enforce the law, which is to say they have penalties that they can impose, and so they act as the executive. But then they also, many of them have in-house tribunals to adjudicate the prosecutions that they bring, and so they were taking on a judicial role as well. And this year, you saw a little pushback on that from the Supreme Court of the United States in really two cases that come to mind first, and we can talk about others, but the ones I think are maybe most important are the Loper Bright case, which involved a fishing vessel, but the bottom line is that it was challenging something called Chevron deference in the law, which was a 40-year-old precedent in which the Supreme Court had said, when Congress writes a statute that is ambiguous or maybe there's gaps to fill, if it's filled in reasonably by an administrative agency, the court is simply going to defer to the agency's view of what that law is.
Right.
The Supreme Court here has said, no, we actually think that's an abrogation of the judicial duty or an abdication of the judicial duty. And it's our job to say what the law is. And it's our job to say what the best interpretation of Congress's statute is. And the administrative agencies really can't be in the situation of both enforcing the law, but then also defining the scope of their own power by rewriting, in effect, statutes. And so I think that case is going to have major consequences. We have maybe, we did not litigate the Loper Bright or its companion case, Relentless. We were amicus in the cases, certainly, and we were supportive of that. We had our own cases going up this term that presented the exact same issue. And sometimes it's a bit of a toss-up as to what case the Supreme Court takes. And, it might have been us, it might have been the other people who got Loper Bright. But the result of that is that we had two cases that were pending cert petitions on the same issue that were then remanded. So our petitions were granted, the lower court decisions that went against us were vacated, and they were remanded for reconsideration by the lower courts in light of the local right decision, because in those cases, I'll just name them, the Casey Transport versus U.S. Department of Labor and Foster versus U.S. Department of Agriculture. The lower courts had looked at an ambiguous statute that we thought should protect our clients' property rights or rights to engage in business activities. The lower court cases went against them on the basis of the agency's interpretation of the statutes that we think were wrong. But
Right.
the lower courts just deferred to them and said, well, they may be right, they may be wrong, they're reasonable, therefore we owe them deference. The Supreme Court has said, no, you don't any longer owe them deference. It's actually judicial duty to judge what those statutes mean. And now we'll go back and litigate those cases. And we probably have 7 or 8 other cases going on in the lower courts that all would have hinged on Chevron deference that may have very different outcomes as a result.
What is the standard that they have to apply now, by the way? It's not that they completely ignore the agency's interpretation. What sort of regard do they have to grant to an agency's interpretation now?
I think it's just persuasive. It's just the agency's making an argument, right? If they have expertise, they bring it forward and they say, here's why we believe this is the best interpretation of the statute. But statutory interpretation has a whole, hundreds of years history of canons of interpretation that very infrequently really depend on that so-called agency expertise. Maybe the expertise relies on factual matters about the subject, but when you're looking at the text of the statute, it's often very clear. And you didn't ask this, but I think there's some chatter now of, well, how much is this decision really going to mean, the local right decision?
Right. That was what I was going to ask you next again, because I think we chatted a little bit about that. Some people are saying it's not going to practically make that much difference, but you think it might.
I think it'll make a big difference. But
Okay.
what people are looking at, and I think they're right to look at it, is they're just noticing that a fair number of statutes that Congress writes are ambiguous. They give powers to protect to act in the public interest or some broad phrase like that. And who knows what that means? That's so vague. It's really a non-objective term. There are a lot of statutes that have terminology like that you look at it and you think, well, it's not very clear what Congress might have meant. And I think the people who wonder or think that local right might not have much of an effect are looking at that and saying, okay, but all the court is saying is that we can't defer to an agency's interpretation of an ambiguous statute. But if Congress intended to give a very large scope of action or a very large range of activity to the agency, well, that is the proper interpretation of that statute. And so some people are looking at that and saying, Congress could just continue in that direction. They could continue to have ambiguous statutes with very broad terms. And in a sense, the best interpretation by a court would then be to give the agency a lot of power.
Right.
And so I understand that objection. I think that, of course, that might happen. We don't know what is going to happen in the lower courts in the future years. But I think it sets up an interesting sort of next opportunity and maybe demonstrates the way that legal change is incremental and why a public interest firm like Pacific Legal Foundation has a long-term strategy. Yes, it's possible that Congress will enact statutes with broader ambiguous terminology. And it's true that some of the current statutes out there on the federal statute books are pretty ambiguous. But this kind of gets us back to a debate that we were having in the 1930s about what is the proper role of the separation of powers with respect to delegating legislative authority to administrative agencies. There is a thing that goes back hundreds of years, came to a head in federal adjudication in the 1930s called the non-delegation doctrine. And the idea there is that a legislature shouldn't be giving up its power to the executive branch. And if it's writing really broad statutes that don't have much meaning except at the discretion of the executive, our argument would be effectively, this is an improper delegation of legislative authority to the executive. And the right thing for court to do in that case is to narrow or even strike down those statutes and say, go back, Congress, and write something that respects your legislative role. And we might see that come as sort of the next big debate. So time will tell exactly what local right means. It no doubt means that a lot of people who would have been pushed out of court based on Chevron deference to the administrative agency will now have an opportunity to present their arguments to a court who will have to listen to them in good faith and decide what the best meaning is. That's certainly going to help a lot of people. I don't think that can be doubted. Whether Congress might then try to undermine this decision, or the agencies might claim that certain statutes now give them more scope of authority than some of us think, they'll make those arguments, but it may bring the non-delegation argument into play. The other big case that was there this term that I want to mention was the Jarkissi versus SEC case. That was a really complicated case involving in-house prosecution of someone by the Securities and Exchange Commission for violations of the Securities and Exchange Act. And what ended up getting decided was really whether it's proper to bring somebody to sort of enforce a fraud-like claim against somebody. So they said he violated laws that amounted to something like fraud. Is it proper to do that in-house, or does the Constitution require, if you're charged with fraud, it's a common law crime that's been known to the law for hundreds and hundreds of years, are you due a neutral adjudicator in an Article III court? And the Supreme Court said, yes, you're entitled to a jury in these cases. And
Wow.
I think that's going to have a major impact on the way the administrative agencies prosecute people. If you just look around, for instance, at the SEC in particular, I don't have the precise statistics sort of in front of me on top of mind, but it's something roughly like when they prosecute people in Article III courts, they prevail about 70% of the time. Some people argue it's much less than that, but depending on how you read this. When they prosecute people in their own in-house tribunals, it's 95, 97% of the time. So you can see just that gap suggests that there's a real advantage to the government to keep people inside the adjudicative in-house adjudication in the administrative agency and not go before a neutral magistrate in a real court. So I think Jarkissi also will have a big impact in that regard. And again, Pacific Legal Foundation has been very active in that field. We have a project in-house called End Agency Adjudication, which we've been pursuing exactly this issue, not only the jury trial issue, but other due process problems that occur in administrative tribunals, rules of evidence, the ability to confront witnesses, problems like this. And we have half a dozen or more cases going on in the lower courts that will benefit from Jarkissi and maybe set up sort of the next questions pushing the boundaries of separation of powers.
And so these two cases are, of course, very positive development for sort of reinforcing checks and balances, which is one of the core principles on which our nation was founded. Again, you wanted to provide checks against any one branch of government being filled with people who had too much ambition for power and tyranny. That was the vision. Of course, you can't really do that perfectly ever, but try to restore that balance. Were there any other cases that you felt worked again towards reestablishing separation of powers, checks and balances, or are we going to maybe talk about some against ones?
Yeah, well, we can talk about the against ones. I think these just go in a long line of the last several terms. There's been some interesting action around the appointments clause, whether the people who make the rules for the administrative agencies are really under the control of the president, can be fired by the president when they're not acting according to the policy of an elected official. That's been going in the right direction. Lober Bright and Jarkissi now are going in the right direction. So I think what we're seeing is multiple years in almost all the decisions that I've seen. The only thing that involves sort of presidential power that one could argue maybe goes in the wrong direction or another direction is the Trump immunity case, which I'm happy to talk about. It's not at all, but it's interesting because people bring it up when you talk about presidential power. I think what you're seeing for several years now is every decision that this court has made with respect to separation of powers, sort of culminating this term in Lober Bright and Jarkissi, are about putting the legislature and the executive in their proper lanes. And this is almost conventional wisdom. It's not original to me and maybe almost a trope at this point. But I think what the Supreme Court is doing is looking at Congress and saying, we want you to get back to legislating. We don't want the executive branch to be growing in the scope of its powers to take over legislative functions. And that means you have to be enacting legislation. If you look at, say, one of the gun case that came up this year.
The NRA one?
Not the NRA one. That was the Vulo.
Okay, that was a free speech case. Yeah.
It was a free speech, was interesting, but they had that. Now it's just off the tip of my tongue and it's escaping me. But in the Garland versus the Garland case involving the bump stocks and the ban.
Okay.
The Tobacco and Firearms Agency had said these are illegal. They meet the definition of a machine gun, and it was just a pretty straightforward textual reading of the statute where Supreme Court said, look, we can agree that Congress could ban these things, and we don't like them. They're dangerous. With that, that horrible event in Las Vegas that sort of gave rise to the administrative rulemaking that led to the change in law. But their point was Congress didn't actually write down that these things were illegal. And
Right.
we can't allow administrative agencies to just give them power that Congress didn't give them. So again, the trend is Supreme Court of the United States looking at Congress, I think, and saying, you need to do your job in some sense. You need to write down the laws and make illegal the things you want to make. It has to come from elected representatives that are accountable to people. It can't come from appointed, unelected bureaucrats in the administrative agencies. And in one sense, that's not directly about individual rights, but we care about separation of powers. I think the Supreme Court ultimately cares about separation of powers because we care about freedom, and we think the separation of powers over the long term tends toward an individual rights respecting regime, and that accountability is part of it. But as a lot of cases will show you, the Supreme Court might allow Congress to do a lot of things that we might not want Congress to do, or maybe we might not think is proper. What Supreme Court seems to be most concerned about in these last few terms is Congress has got to do the job that it has before as a legislature, and the executive has to do the enforcing. We don't want these two branches mixing because it leads to dangerous results, dangerous in the long term for liberty.
So when I think then about this Trump immunity case, Trump versus United States, the very last opinion to be released in the term, it doesn't contradict the trend that you just spoke about because it doesn't directly involve the role of the legislature. It's not involving, legislators delegating to the executive in any way. And yet I certainly had the sense, many had the sense that it was a bit of a default on separation of powers, that the court should reserve for itself a bigger role in serving as a check on the executive. What did you think about it?
Yeah, I thought so too. And, I mentioned it, and I mentioned it in context of these other cases because the way in which some people say, well, they seem at odds, they seem confused. They're just noticing that on the one hand, they seem to have put more power in the hands of the executive, or at least more discretion and more discretion in the hands of
lack of accountability, at least, right?
In the executive branch. And on the other hand, all these other cases I'm discussing and the trends over the last few years have been sort of removing discretion and removing power from administrative agencies and the executive branch and trying to locate them again, either in the courts or in the legislature, depending on how the Supreme Court views the separation of powers. I don't have deep thoughts about the Trump decision. My sense is that I didn't really understand why it came out the way it did. It doesn't make sense to me that it doesn't seem like it's a textualist decision. It doesn't seem like it's particularly grounded in originalism.
Right.
It seems like a kind of functional decision. And this is just me speaking off the cuff. I found it unusual. I found it hard to understand because I don't think I take this court at its word, all the time. It's a court over the last decade or two that I think has basically done what it says it's doing. It's not engaged in real politics. It's not, the court under Oliver Wendell Holmes or something where, there was something different going on in the writing than I think was going on in the policy making below or the New Deal court. I think it's an honest court in that sense, or at least it's a transparent court. I don't really follow that in this case. I would have thought it had a different outcome under kind of the originalist grounds that most of the justices adhere to, or the textualist grounds that many of them adhere to. If I had to guess, it's a decision by the court that they have two dangers. They have an American culture and a political culture that is becoming increasingly tribal and filled with recrimination and resentment. And then on the other hand, you have an executive who is a bad actor in Trump, and they wanted to ignore the bad actor in Trump to come up with a rule that probably would protect us against the next 20 years being filled with one presidential administration after another suing its predecessor. And I think, we just hold our breath and say Trump will be, is either never going to be in office again or will be in and out of office, and that will be a different era coming forward. And will be protected against maybe a continuation of these kinds of recriminations by the fact that one presidential administration is not likely to sue the previous one, or it's just a mistake. But to me, it struck me as more of a pragmatic decision than I'm accustomed to from the court.
Yeah, I've spoken at length with Bruce Fine. I'm not sure if you're familiar with him.
I don't know him, but I know of his work. Yeah.
Okay. And, he was sort of dumbfounded at how they came up with that ruling. And I think he actually commented that he believed it was the worst decision since Dred Scott. Now, I don't know if you're that extreme about it,
Yeah.
but
I don't think I would say that. I mean,
okay.
it's a big issue, right? It deals with presidential immunity, so it could have long lasting. But comparing anything to Dred Scott is dangerous. And in any given few years, there's a whopper here and there, and I don't count this one as particularly worse. But time will tell. We don't know who the next president, the next 10 presidents will be, and how this thing will reverberate, or whether it'll be reconsidered. Someday when there are cooler heads after the current political environment.
You don't at Pacific Legal litigate much on First Amendment, or do you?
We really don't. We do some free speech work, but it's incidental to these programs. So unless it touches property rights, equality or opportunity, or separation of powers, we don't do it. That said, we probably have 15 cases or so going on right now that are free speech cases, and we've had three cases at the U.S. Supreme Court in the last 30 years that are on First Amendment issues. So we're not foreigners to free speech, but we don't have a standalone free speech practice at this point. In part, it's well covered, right? I mean, when you think about First Amendment, generally, places like Alliance Defending Freedom deals almost exclusively with religion clauses, and places like FIRE deal with student speech, and now they're broadening their footprint. Everyone wants to cover free speech. And so when I was looking at our strategy some years ago, 5 years ago or so, we were doing a lot of free speech cases, and I started to reconsider, is it necessary for us to be doing them? It's fun work to do very often. It's important work. But if every time you look at a case, you realize there's 3 or 4 other public interest law firms that could take it or would take it, how important is it for us to use our resources on that, as opposed to maximizing this window of opportunity, I think, that we have before the courts to make real progress on separation of powers or property rights or on the 14th Amendment, where if we can get the right cases to the courts, well-framed cases, litigated rigorously, I think we'll probably get positive decisions in the direction of freedom on the issues that we care most about. So we sort of still do free speech claims, but we don't have a free speech practice. And the way that comes up, for instance, is we had a case against the city of Malibu, California, and the California Coastal Commission because they were prohibiting people from putting signs on their private property to say that the property was private. And
interesting.
on one hand, it's a property rights case. On the other hand, the natural claim there is government. You can't just tell people that they're not allowed to say true things about their own property. And that is settling, but I think maybe they just fear losing it, but end up settling out. Or we have cases involving economic opportunity, where we have a company that paints murals, for instance, in Texas right now, and they were banned by a series of ordinances that just disallowed murals. And there are various claims you can make related to economic liberty there that would keep this business in business. But one of them is sort of obvious, in that you're prohibiting painting murals on the outside of my building that I own, and there's nothing obscene or offensive about these murals. Or maybe you could paint offensive murals, but these don't happen to be. The point is, they're just banning something that touches on the First Amendment. So you'll bring a First Amendment claim in a case like that. So, and we have a First Amendment claim, I think, in a case in California where we're challenging mandated inclusion of DEI, diversity, equity, inclusion related subjects in medical continuing education. And we're representing doctors who teach those courses, who say the ideas they're asking me to teach as a requirement I oppose them, and I think they're false, and I don't want to have them coming out of my mouth, and I think there's a compelled speech claim there. So it's mainly an effort around our view about what equal protection requires, or at least a vibe around equal protection that touches on DEI, and a First Amendment claim was natural in that case. So we do some free speech claims, but they're incidental to our main purposes in equality and property and separation of powers.
When you were talking about signs on property, there was a case that Reason wrote about recently, a Tennessee case. I don't know if you're familiar with it. It says a federal judge has ruled that a Tennessee woman's F 'em both 2024 yard sign is protected speech. So
Yeah, I
my
saw that.
my comment was there ever any question? Of course it is. But it's particularly, this year when you've got the selection between two not great decisions, to not let people express their frustration about it on their own property with a sign, it seems
Yeah,
not consistent with the First Amendment to the Constitution. Um, when you talked about the Fourth Amendment practice that you have in connection with the property practice, right?
yeah,
It's tied up with so you do see privacy, which everybody sees Fourth Amendment is just about privacy, but you see it as tied up in the use of one's property, right?
for sure. Yeah, I mean, part of what we're trying to do is emphasize or get the lower courts to more seriously consider the Supreme Court statements about that the origins of the Fourth Amendment were security and property, and privacy is not irrelevant, I think, but it's the expected interest that you have in your privacy is not the right test in our view. It's a property based approach, and so we're interested in a lot of Fourth Amendment issues. I would say we just haven't gotten around to things in digital privacy. Perhaps we actually don't have the expertise in house to do much of that. It's a kind of confusing world where the Constitution begins and where contract rights end or begin there, and we haven't gotten much into that. But when we talk about Fourth Amendment rights, we're talking about, for instance, we have a case in Billings, Montana, where they enacted a statute that, as a condition of getting a license to practice massage in the city, you have to sign a waiver of your Fourth Amendment right for a warrant if somebody wants to enter your property. And this
Right.
is particularly difficult for people who are, one can imagine what they're trying to get to, right? They're trying to make it easy for them to enter massage parlors that they think are prostitution. And
Sure.
I understand that. Although they can do surveillance, it's pretty obvious when that's occurring, and it wouldn't be hard for them to get a warrant. And I guess that's one of our points is if you really are after that, you can get a warrant. The people who we're representing are people who maybe practice out of their home or maybe travel to homes, and they don't want that. There's also requirements that they give client records to the government without a warrant, and they don't want to do that either. So it's cases like that. And where we're trying to push on this is maybe more prosaic and not the sexiest or digital privacy stuff. It's just everything requires a license to do today. And if you're going to start requiring sort of conditioning the exercise of constitutional rights, particularly your right to request a warrant before somebody comes to your property on getting a license, you're basically going to undermine the constitutional protections for property or privacy across the board. So we're trying to put an end to that with kind of unconstitutional conditions, doctrine style cases. And the other thing that we see that we're doing more of is the government is always trying to expand the closely regulated industry kind of loophole around Fourth Amendment where they can enter businesses if it's so-called closely regulated. Well, the Supreme Court has had a very narrow window of what they consider viable as closely regulated industries that don't require a government to get a warrant to enter the premises. And the governments around the country are always trying to expand the industry that they're putting on that list. And so we'd love to get a case up to the Supreme Court to clarify either that is not a legitimate exception at all to the warrant requirement, or if it is, it's
Right.
very, very narrow and has to be, all the burdens have to be on the government to show it. So those are the kinds of things that we're doing in the Fourth Amendment space.
I remember studying the cases about that in law school. It had to do with barber shops. And, they're obviously with a massage parlor, even if there's nothing untoward of the type that you were describing going on in the massage parlor, it's still a place where people are not wearing a whole lot of clothing. And it would be very embarrassing, et cetera, if the agents just barged in unannounced without a warrant, et cetera. And in the barbershop cases, they would talk about things like, oh, there's a man who has a toupee and he's going to be so embarrassed because obviously they removed the toupee to cut whatever of the other hair and stuff. And then he'd be seen without it, or, that was the recitation that they, right, that they made in the cases. But it would be great to see those overturned, I think, because, if the test is reasonable expectation of privacy, and then they can say, well, your expectation isn't reasonable because we regulate it, so forget you. All they have to do is regulate everything in the world, and then suddenly you don't have this expectation. But you haven't gotten involved in say FISA Section 702 or any of these warrantless surveillance and et cetera. Okay.
No, it's interesting. I mean, yeah, some of the other things, like we're interested in administrative search doctrine, so-called administrative search doctrine, the idea that the standards for granting a warrant can be much lower if it's like an administrative search. People are just inspectors or going like building inspectors or routine inspections. But sometimes this can really implicate deep concerns with respect to privacy or just keeping your property safe from people wandering around it. When you talk about nowadays, there are hundreds of cities around the country that have rental inspections. So if you are in a rental property, you may be just subject to somebody coming, knocking on your door and walking through the property. And ostensibly what they're looking for is, is the electricity working? Is the air conditioning working? Is the roof leaking? But they're also wandering around your house, and who knows what they see. You may or may not be prepared for them, but the standard for those warrants are very low. And we don't think it's legitimate. So we'd like to get administrative search doctrine reconsidered. And then something we haven't done a lot of cases on, but we're quite interested in, is something I know you've been involved in, Amy, with your Fourth Amendment writing, is just the third party doctrine. Is, oftentimes you're giving a lot of information to third parties, and the government is getting all of that without a warrant or without even informing you, so that you can object to the giving. And there are real problems there. They're Fourth Amendment problems. And so setting up public interest cases that might make their way to the Supreme Court is important to us. It's difficult to set those cases up.
So I'm smiling because I've got one for you. So Oren Kerr, one day ago, tweeted about a case in the Fourth Circuit. Are you familiar with this one?
I don't think so.
No. Okay. So it says geofencing of Google location history records, not a search, according to the Fourth Circuit, as it was only 2 hours in duration and the third party doctrine applies. So if you're familiar with that Carpenter case from 2018, here we have a case, and I'll get the title for you here in a second. Let me pull it up. Okay, it is United States versus Okello Chatry. So Okello T. Chatry. So you say United States versus Chatry, Chatrie. And they went ahead and decided that the Carpenter ruling, which said that if you have 127 days of cell site location data, that would require a warrant. Here, it's only 2 hours, and so the third party doctrine applies, they say, right? So I think that's an opportunity.
Yeah.
Could be.
Yeah, I'll look into that. I appreciate you bringing it. But that's kind of, some of these doctrines, both administrative warrants, third party doctrine, I think both of these doctrines kind of arose out of cases in the late 1960s, maybe 1967, maybe both cases, Camara and third party doctrine is escaping me at the moment. But
is that White or something? Maybe I can't remember. But it was the one just before Smith and Miller when they expanded it in the 70s in the way that was not valid. Yeah.
Yeah. And so, both of them are of relatively recent vintage. They are really expanding the authority of governments to act without warrants. And you can understand why in some cases, crime control and other things, but many of the reasons tread on the core reasons for having the Fourth Amendment. So with respect to FISA, we haven't done any cases there. That's interesting. I'm not opposed to doing them, but part of the art of public interest law is finding the right vehicles, finding cases that present a fact pattern and present a circumstance and present a clear conflict in the law that judges can kind of sink their teeth into. And it can be very difficult to do public interest law if you're trying to overturn longstanding precedents, especially around the Fourth Amendment. And you're also dealing with sort of national security and, documents that might be difficult to get to just because of the participants involved in some of these cases, a lot of foreign people living in foreign locations. So it's not to say it's impossible to build a case like that, but it's a hard subject to build a public interest case around, because what you're looking for is incremental change. So I'm usually looking for, well, where's the conflicts in the law and what's the next step we can take to advocate for the right position? And you just do it step by step by step. Whereas an attack on FISA warrants might be, 3 steps ahead. And so you might, in some sense, you could entrench a bad law because the court's not ready or isn't prepared or the conflict isn't there yet to sort of give enough meat for the appellate courts to dig in one side versus the other. But I don't know everything about that subject, so I wouldn't want to make a conclusion about it. But it's one reason why I don't think we have a rich case development around FISA. It's just, it's not sort of the next increment as opposed to even if there's a lot of bad violation going on there.
Yeah, this chatry might be a good next increment, because a lot of people were dissatisfied with the Carpenter ruling, saying this is very narrow. You're just telling us 127 days of cell site location data. Somehow that's too much. Where would you draw the line exactly? And a lot of people, have been speculating. So here we have something that the Fourth Circuit could tee up. It could be very interesting. I mean, for me, when you think of privacy, I think of it as a state. Privacy is not a right. It's a state that we can create for ourselves using our rights to property and contract. And I think so many of the ways that privacy has been protected in the law for decades have actually served to undermine our ability to maintain states of privacy, because it was put on a pragmatic foundation. But this brings up kind of a broader point. And, where is the role for public interest litigation, and where is the role for maybe going to legislation? And it has to do with the issue of standing. Both Edward Snowden and then other people have complained as well that challenging something like FISA or any bulk or warrantless surveillance program. I don't know if they're all bulk these days, but there's vast warrantless surveillance programs that the government is conducting, and challenging those is difficult because it's difficult to get standing to even prove that you're one of the people who is being injured by the program at issue, et cetera. And this is one of the reasons that Snowden argued that he had to do what he did, and he's living in Russia for it too, to this day. So whereas in my writing, I have a great theoretical argument that you could make before a court if you had the right case. The challenge is always to actually get that case and get standing. And we saw this issue come up in the Murphy case, Murphy versus Missouri, the free speech case involving the Biden administration pressuring social media companies to remove content. The court ended up not siding with the Biden administration, as so many of the headlines will read, but making a narrow ruling on the ground of standing, saying that the plaintiffs in those cases did not have standing. What did you think of that ruling? And then how would you pursue, your rights against overreaching executive power in that sort of situation going forward?
Yeah, there are some people in my community who think all standing is bunk, that the doctrine is not proper at all. I don't think I go that far. I think there's some aspect of the idea of standing that relates to the Article 3 power and the limitations on the judiciary. Its goal is it's sort of a prerogative is to decide cases and controversies. And I think they have to be cases and controversies between individuals or between individuals and the government, as opposed to answering abstract questions. So I think you have to show some injury. I think that injury ought to be fairly light if it has a tangible impact on your life. So I think with Murphy, I probably would have gone on to decide the merits of that case. I think that if I were the court in that case, I think they probably did show enough injury to show that their communications are impacted, their relationship to the social media networks are impacted. The government is probably going to keep doing it. I mean, it seemed pretty clear from your argument, Aurelius, that the government just does this kind of behavior. They try to influence the social media networks behind the scenes. So, I probably would have gone the other way on it. But I know that's an answer for you, but I tend to think there's like some standing hurdle, but it should be very low. And it should be only high enough to make sure the government the courts are not entering into sort of abstract philosophical debates about the law, but actually solving real controversies that impact people. And, standing is one of those areas of law where I think it's in flux. It's a mess in the lower courts. If you look at any 20 cases that are dismissed on standing, you'll find different standards being used. And I think this is just the first of many cases we're going to see in the next few terms where the court's going to try to grapple with what its standing requirements are, because it's got to clarify, I think, for the lower courts exactly what level of injury is required.
A test that was articulated in that case sort of really called to mind something in philosophy that I'll explain to you in a second. But the test was that they couldn't have standing if they couldn't show that the content wouldn't have been removed but for the interference with the government, the pressure from the government.
Yeah.
And what came to my mind was Kant, when Kant said, what is the test for an action that qualifies as good? It's good only if the motive of duty is sufficient to determine the action, meaning that you have to be sure that you are acting primarily out of duty,
Hmm.
not for any interest of your own or anything that was utilitarian or pragmatic or anything else. It was only out of duty, some sort of altruistic duty. And, that leaves somebody in the situation where they really can never be sure that they're doing a good action unless they really don't want to do it at all, right? They don't have any other motives that make them want to do it. Then they can be really sure, that they hate doing this thing. Then they're sure that it's good, right? And similarly, if there's any other reason that Facebook might have taken down this content because, hey, the person who worked in content moderation and the people who trained him and even the people who wrote the standards themselves sort of agree with the pro-COVID vaccine agenda, or, in some cases now we're seeing climate, information about climate being deemed disinformation. Maybe they normatively agree substantively with the stuff and they want to moderate it for that reason. Who is ever going to be able to get standing, even if they can show that the government said some pretty blatant, either direct or indirect threats to the company to get them to put it down, right? I mean, it's really that action that they need to deter. It's the government interference with the platforms that needs to be deterred. And whether or not you could tell exactly what made the Facebook person, hit the magic button that made the content go away, I don't know that it should be given that big a role in the test.
Yeah. Well, now you're just speaking to, all of the things that keep me up at night in terms of designing cases and doing good public interest law, because you've got to have clients that have a real injury, even if they can sort of make standing arguments. It's a better case. It hits the judges in a different way if the injury is tangible. And now we're not getting deeply into the Murphy case, but more Hornback law and standing. If you just what you talked about, maybe for your listeners or viewers, you've got to have an injury, and you've got to be able to show that injury. It's got to be concrete in some sense, or it's got to be imminent if it's not yet happened. If it's a pre-enforcement challenge, you have to show causation for standing. You have to show that the thing that you're complaining about, or the person that you're complaining about, caused the injury to you. Mm-hmm. Otherwise, it's no longer really a case or controversy between the two of you that a judge can adjudicate. And then you've got to show redressability. It's got to be that the judge's decision can actually solve that problem or can cure that injury in some sense. And if all those conditions hold, the judges look at it and say, well, are you really asking me to decide a case in controversy, or are you asking me to answer kind of an abstract question about what's right or wrong here? And here, the court thought it fell on one side of the line versus the other side of the line. I think you could have argued it. I think it could easily fall on the other side of the line in this case. But when I say it's the kind of thing that keeps me up at night. It's that, or at least the thing that energizes me about setting up good public interest cases, is the natural plaintiffs in a case like this are social media companies themselves that are being pressured, right? Because then you don't have a problem in building the record where a third party is saying, well, that other person would have acted but for the other person. You don't have the support of the third party.
Yes.
You really need to find some smaller, maybe, there are probably
the ones that are pushed out of business by the big tech platforms like Amazon, those ones. Yeah. Uh-huh.
Yeah. About that certainly from
I know a little bit about that, Larry.
Yeah. So, and that's the natural plaintiffs for these kinds of cases, because
yes,
otherwise you're caught. If you can't build that record early and demonstrate your standing, you're just going to have trouble going all the way up, and you might make it all the way to the United States Supreme Court and then get crushed on a kind of procedural ruling on standing.
Or they'll rule in your favor, but then all the evidence is so old, and good luck trying to gather it when you get back down and you're able to do more discovery or whatever too, right? So there's all that. Oh my gosh.
I'll talk about one. This is just a complete pivot, but I wanted to talk about one of the other areas that PLF practices in this sort of equality or race and sex-based discrimination is the kind of case from the term that I think a lot of people out there in the elite practice looked at and said, oh, that seems weird that the court didn't grant that this year. It was one of our cases called the Coalition for TJ versus Thomas Jefferson High School. And it was a case in which the Thomas Jefferson High School, which is sort of a fancy public school in Virginia, has an admissions process because the demand to get in there is so high. It's like a magnet school. They can only accept a certain number of people. And they changed their admission standards in order to racially balance the constituents or the students at the school. And we argued, in light of the Students for Fair Admissions case last term, that, it's been very clear now that you can't use racial balancing as a basis for policies if you're a public school, or even if you're a private school that takes on a lot of public money in the way that say Harvard did in that case. And we thought the next question to answer was, well, what about covert discrimination, where they don't write the policy to say we want 12% Black students and 15% Latino students, but what we want to do is do a study to figure out where those racial constituents come from based on zip code or based on school or feeder school. And then we're going to limit the things so that we get exactly the racial balance we want, even without using the word race. We presented that question, and it was really interesting. We won it at the trial court, and that was that it was violated the Equal Protection Clause, their admissions policy. We were reversed in the Fourth Circuit, and then we brought an emergency petition to the Supreme Court at that moment because it was on an injunction. And the Supreme Court, basically, we had 4 justices join an opinion saying, we're not going to take it because the procedural posture, we want to wait till the final decision, but we should be taking this case. So we knew there were 4 justices who were very interested in the case. And then when the final decision came around, it was a denial of cert with 2 Justices Thomas and Alito saying, we obviously should have taken this case. So it was sort of a fascinating thing. But, I mentioned that because this is going on everywhere now, even in the wake of SFA, Students for Fair Admissions case, where the court has basically said, ending racial discrimination means ending all of it. And yet we have dozens of cases now going on in the lower courts where we're fighting explicit racial preferences or discrimination or quotas going on for, say, the appointment to various government boards or admissions in public high schools where there are sort of elite high schools where the admissions is limited. Or, we had one case that was also denied cert last year, but with a statement from the denial from Justice Alito saying they should have taken it, that involved a racial preference for getting in line for COVID medication. And there's all of these racial preferences popping up in the wake of the cultural move toward, quote, equity. And we feel like we have to fight it because we're moving in a long, good direction in terms of racial equality in America. And all of a sudden it's kind of turned on its heel because the traditional civil rights movement has turned in the direction of promoting racial discrimination under one guise or another, usually under the guise of equity. So there's a lot of the cases we're taking right now. We've probably got, 24 cases that all involve government programs that are either expressly or covertly discriminating in the benefits of burdens, distribution of benefits or burdens of one kind or another based on race. And it's pretty wild that we're still talking about that in 2024. But the TJ case was denied this term. And yet, because so many other schools are doing the same thing, we have cases teed up behind it. So,
Sure.
we have another cert petition going up. And I'm hopeful maybe this term that they'll take a case from Boston that is doing the exact same thing.
You would think that the court would not have to take up another case just to say, yeah, we really meant what we said earlier, don't you think?
You would hope, but I'll talk about another case from PLF this last term that we had at the court called Sheets versus County of El Dorado, which was about building permits. And the question is, you're going to build a house, you're going to get a building permit. What can the government demand of you as a condition of getting your building permit? And this really was a case in which we've had to go there 4 times now over 40 years to get them to say the same thing over and over. The first case was in 1987, a case called Nolan versus California Coastal Commission, where the Coastal Commission, if you're having a beachfront house, what they would say is, in order to get a permit to build a home, you have to dedicate the beach portion of your property to public property.
Wow.
And we won that at the Supreme Court in 1987. Justice Scalia, in a memorable opinion, said it was out and out extortion, and it was an unconstitutional condition on your property rights to demand property that the government wouldn't otherwise be entitled to. without compensation. And we thought, oh, okay, we won that. What government started doing is pivoting, and they said, well, okay, the Supreme Court has said we can't take land as a condition of the building permit. Maybe we can take money, and then we can use that money to buy land. And so, we had another case in 2013 in which they said, no, you actually can't take money, unless it's to mitigate some public cost that you're imposing by your development. That would be a different story.
Sure.
And we said, okay, well, we won that, 2013. And then we saw governments pivot, especially California, where they said, okay, we can't take land or money. But those decisions involved like permit conditions imposed by executive branch, like agencies that issue permits. What if the legislature passes a law? That's different because that's the legislature. And so, well, it doesn't seem like it's different. So this year in Sheets versus County of El Dorado, it was a takings case, essentially unconstitutional conditions case, where the Supreme Court said, look, it doesn't matter if it's money, if it's land, if it's the legislature, if it's the executive branch.
Right.
No one can demand something from you as a condition of getting a building permit unless it's directly related to some adverse public cost you're imposing by that development. And so the kind of classic example would be if you're getting a permit to build a shopping mall, and as a result, they've got to widen the roads all around you or put up stop.
Right. Sure.
Well, as a condition of the permit, we're going to make you pay for the wide roadening. Okay. Whatever we think of that, I can buy that. It's a sort of tit for tat, or you're causing this cost on the public. We're recovering that cost on the public. But what you can't do is you have me over a barrel. In order to use your land, you need a permit, and we're just going to extract whatever we think we need from you.
Yeah.
The Supreme Court finally said no. I think after 4 trips to the Supreme Court over 40 years, we finally have that locked down. But you can see sometimes you do have to be relentless about it. And that's one of the things that I love working at PLF is that we've got a lot of resources, we've got a lot of talent, and we do have sort of internalized ethic of being relentless. We know we win one, they're going to try to get around it. We're going to keep at it until we get the principles locked into the law as best we can.
Yeah, and it sounds like you are doing a lot of good, and you have a great record before the court as well of success. So I think you're definitely doing something right. If people want to get involved, what should they do?
Just come to pacificlegal.org and they can sign up for our newsletter. We don't hit you with a ton of spam. You're just going to get an occasional information, and you can sign up for more information if you want more than that. But if you just sign up on the bottom of our website for our newsletter, you'll get that, and you'll just learn more about what we do. And we've had 20 cases at the U.S. Supreme Court. We've won 18 of them over the years. We have something like 155 cases simultaneously going on in almost 40 states around the country right now on all kinds of subjects involving separation of powers, property, and equality and opportunity. And we're doing as much as we can.
It's great to see, Larry. It's great to see. And you've been with them for how long now?
Almost 10 years.
Okay. Excellent. Excellent. Well, thank you very much for your time this afternoon. And, as Supreme Court gets into some interesting cases next term and stuff, maybe we will have you back again and remind people about all of the great work that you guys do. But I appreciate your time. Thank you.
I would love that. Thanks, Amy. Good talking with you.
Okay. Okay.